Welcome into the Jackson Kelly podcast. I am Josh Copen, the public relations specialist at the firm, joined now by one of our members, Robby Aliff, but we all like to call him Robby. And so Robby will be joining us. And Rob, why don't you tell everyone a little bit about yourself, what you do at the firm, and maybe, if you want, I think this is an interesting way to start. How did you get into law?
Thanks, Josh. Yeah, and you can call me Rob or Robby, either one. I'll answer to anything. So when I grew up in Oak Hill, West Virginia, I didn't have any lawyers in my family, didn't know a lot of lawyers, but I noticed as a kid that a lot of the people who were in politics and seemed to be doing important things had law degrees. So I early on started telling folks that I wanted to grow up to be an honest lawyer. And that's what I told people, even though I had, frankly, no clue what that really meant. I finished up from my undergraduate degree at Washington and Lee University in Lexington, Virginia, always thinking that I would eventually potentially go to law school. My undergraduate degree was in psychology. I did end up at law school at Washington and Lee after taking 3 years off between undergrad and law, and finished my law degree in 97 and was immediately an associate at Jackson Kelly, where I had worked for 2 summers. So I have been a lifer at Jackson Kelly since 1997 and just celebrated my 25th anniversary with the law firm on May 1st. So I've been here a long time. I do primarily medical professional liability litigation, meaning I defend doctors, hospitals, healthcare providers, generally when they are sued by others. I do some other general litigation work as well, and have recently started offering up services as a mediator in litigated cases, and look forward to expanding that work as well.
Great, and I appreciate you running down. And they can find you on our website if they go to www.jacksonkelly.com under professionals, and you're right there, and they get more of a breakdown of your biography, your education, admissions, legal experience, all that, which is quite impressive. And I don't just say that just because I work with you. It's rather impressive, the work you've done. And so today we wanted to look at kind of almost a legal 101, right, if you will, and that is the term depositions. Why don't we start with, everyone hears that, everyone probably is like, oh, I know what that is, I see it on TV. And so why don't you help us understand, what is a deposition?
A deposition is testimony provided by an individual which is under oath, but it is not in a courtroom. So it is usually done in a conference room or by Zoom. It's done in the presence of a court reporter or a stenographer who will take down everything that's being said and transcribe it into a written form. The key to a deposition, though, is that it is done under oath. The oath is administered by the court reporter, him or herself. There is not a judge present, but the court reporter stands in the stead of a judge, at least from the standpoint of making it an official proceeding. And then that testimony, which is then transcribed, can be used as under oath testimony in other proceedings in that particular matter, and sometimes can be used in other matters. The key, and I've said this a couple of times, but the key is the judge isn't there and you're not in a courtroom. So it's different than courtroom testimony where you might be in a trial as a witness. Nonetheless, it is considered as official as in a courtroom or at trial, because you're swearing to tell the truth, the whole truth, and nothing but the truth.
So you kind of got into this a little bit, who's in the room, who's not, given you're not in a court. So what's the role of the court reporter in the deposition?
Sure. The court reporter is usually the only person in the room who is sort of a disinterested third party. The only role of the court reporter is to administer the oath and make sure that the proceeding is, in fact, recorded appropriately and can be transcribed accurately, consistent with the oath and the questions that are being asked. So the court reporter doesn't have a financial or other interest in the outcome of the proceeding. And the other folks in the room are in a different position. Typically in a lawsuit where one individual or one company is suing another company or individual, any party to the lawsuit, so any named person, the person that's sued is usually called the plaintiff, the person that's defending or is being sued is called the defendant. And typically those parties can be present at deposition, and of course they're attorneys. And the attorneys take an active role at the deposition.
So we were going to talk about this a little later, but I think it fits here now. Has it changed at all with Zoom, Teams, WebEx, whatever you want to call it? Are those things allowed in the current culture of, COVID?
I will say, Josh, honestly, COVID has changed everything about how we do depositions and what is and is not the norm. Before COVID, nearly all depositions were done live and in person. So, for example, if I needed to take the deposition of an expert witness in Cleveland, Ohio, I would hop in my car, I would drive the 4+ hours to Cleveland from Charleston, West Virginia, and I would sit in a conference room with the witness. The other lawyer would be there as well, and we would take the deposition live in person. The court reporter would also be present with us at that location. Pre-COVID, there were times when we would do telephone depositions, but honestly, those depositions were few and far between.
Yeah.
When COVID hit and we started doing a lot of work over Zoom and Teams and other video methods, video conferencing methods, we tried early on to stay on top of our cases, continue the work of depositions and other things like that, and it became normal for us to do those by Zoom. In our almost post-COVID world now, we have all realized, all being the parties, the lawyers, the insurance companies who may be paying the bill, even the court reporters have all realized that it is significantly more efficient in most circumstances to do these depositions by Zoom or other video means rather than having everyone travel to a single location. Mm-hmm. So we typically all agree at the beginning of a Zoom deposition that the court reporter can administer an oath remotely. The deponent still raises his or her hand, swears to tell the truth and the whole truth and nothing but the truth. But all of that is done remotely with us looking at each other on a computer screen. So no more long trips from Charleston to Cleveland, or at least typically none of those trips. And that's being done by Zoom these days.
Yeah, and even some judges still are doing things over Zoom and meetings. So it's becoming more and more the norm. Let's talk about the nature of a deposition, if you will. Why are they important to a lawsuit? It's not taking place in the courtroom, so someone will be like, well, is it important then if it's not in the courtroom?
Sure. Well, Josh, one of the things we try to do in litigation is uncover evidence. And evidence can be information that is written. It can be documents, documentary evidence. There could be medical records. There could be contracts. It could be handwritten notes that someone has made. But many times the actual testimony of a witness is among the most important types of evidence that we have in a case. And the way to get that evidence from a witness outside of a courtroom setting is through an under oath deposition. Now, you can go interview someone, and certainly I will do that from time to time, where I just go and meet with somebody and hear what they have to say, and maybe I might take some notes of the information they provide. But honestly, down the road, if they're on the witness stand and I'm asking them the same question I asked them in the informal meeting, and they decide to answer differently, there's really not a whole lot I can do about that, because I don't have prior sworn testimony that I can point to and question them as to why they're testifying differently now than they did previously. So if we want to preserve accurate, under oath, honest testimony, then the best way to do that from a witness is to take a deposition. And then we can have that information not only to prepare for future proceedings such as a trial, but also so that we can develop additional information. I may not be able to ask all of the questions in a courtroom that I might ask during a deposition, because the question that I'm asking may not be relevant. But the breadth of a deposition is much, much, much wider than it might be in a courtroom. And I sometimes tell my my clients who are getting ready to be deposed, that lawyers can ask almost anything in a deposition. Now, I'm sure I can come up with exceptions to that, but the questions that are asked do not have to conform to relevancy, do not have to conform to certain rules that they would have to conform to if we were in a trial in front of a court with a jury. So depositions sometimes can be fishing expeditions, and they can be opportunities for lawyers to find out things that they may not know the answer to, and it's a much safer place to ask those questions for the lawyer.
So as someone who, works in public relations and does not have a law background of any significance like you, is it something that's agreed upon by both parties? The judge is okay with it. I know you explained this a little bit, but, the deposition part of it is the other side understands that this is going on or may even be present?
Sure. Depositions are governed by the West Virginia Rules of Civil Procedure. It's considered an element of what's called discovery within the litigation context. And discovery is nothing more than finding out information. So once a lawsuit is filed, between the time that it is filed and the proceeding has begun until the time that there's a resolution, either through settlement or at a trial, all of that intervening period is generally referred to as a time of discovery. And you can ask written questions of the other parties, and then you can ask questions through deposition of the other parties. And all of those rules are contained in the West Virginia Rules of Civil Procedure. You have to properly notice a deposition. You have to give the other side notice as to where and when it will take place, whether it is going to be by video or in person. You have to conform to certain requirements of the rules as it relates to length of deposition. Sometimes you will have agreement about the timing of depositions or the number of depositions that will be taken. But generally, depositions are widely understood as an appropriate way to ask questions, an appropriate way to ask questions of important witnesses. And usually in the context of what I do, in the context of practicing law in the state of West Virginia, the lawyers tend to get along pretty well. There are certainly times when the lawyers may spar a little bit and not get along as well, but the vast majority of the time we're able to pick up the phone or drop an email to a lawyer on the other side who's representing a party, and we decide what day might be convenient. We decide a time that might be convenient, and we try to comport our depositions so that it's convenient for everybody. The other flip side of that is if we don't have control of a witness, or if we can't agree, sometimes you do subpoena someone. You actually issue an official subpoena, which lawyers can do in lawsuits with the power of the court. And by issuing a proper subpoena to a potential witness, we can force them to show up at a particular place and a particular time. And if they choose not to do that, then they would be potentially in trouble with the court. We could go to the court and ask for sanctions or ask for the person to be held in contempt or to enforce the subpoena to force them to come in and testify. But the vast majority of the time, these are done by agreement of the parties, and we just pick a day, time, and location, or by Zoom, and we were able to get that accommodated.
Okay, and I think you kind of answered this, and you do a great job of knowing where I'm going to go, so I appreciate that. Again, we're talking to Robby Aliff, a member at Jackson Kelly, is how should you prepare for a deposition, and then tied in with that, what is the role of, let's say you're my attorney, Rob, what's your role in a deposition?
Sure. Two really important questions, actually. First of all, how do you prepare for a deposition? I tend to, first of all, it depends on what kind of a witness you are. If you are a fact witness, if you're a defendant, maybe you're a physician who's been sued and you're having to give a deposition as a party to the lawsuit, I might prepare you quite differently than I would a minor fact witness that I simply want to ask a question of, was the light red or green? Mm-hmm. And so if you're a physician or a major witness, or the party that's being sued, I, as your lawyer, have the opportunity to prepare you for your deposition by going over the possible questions that you may be asked, by looking at documents that you may be shown at the time of your deposition, and asked questions about. I'll have the opportunity to talk with you about what other witnesses in the case are saying, what their testimony has been. And I usually like to prepare 2-3 different times before the deposition takes place. I'm not someone who likes to do marathon meetings because I think it's tiring, and I think that you can only go over so much and have it be meaningful. So if I can have 2 or 3 short meetings with you before your deposition, usually that suffices. There have been times when I've had many more meetings than that, depending on the subject matter and the amount of documents or information we need to go over. There are times when I may meet only one time because the information is easy to go over and I don't anticipate it being a very long deposition or an overly detailed deposition. The real answer is we'll meet as long as it takes and as long as the individual is willing to give me time. Obviously, if you're a defendant in a lawsuit, you're being sued and you're the defendant and I'm your lawyer, then when we are meeting to prepare for deposition, assuming that it's just the two of us in the room and all other things being the same, we have an attorney-client privilege about what's being discussed, and we can prepare using that attorney-client privilege so that I can provide you additional information and you can talk to me openly about things that you may be concerned about going into the deposition. If you're a witness I don't represent, but I want to help you get ready, then I don't have that attorney-client privilege, and there certainly wouldn't be the kind of back and forth that there would be if it was a client situation.
So the review could be your own client, or it could be someone you've called as a witness or want to have as a witness, or just for fact or background, but they're not technically your client.
That's correct. An example of that would be, if you represent a company and you may have a minor employee of that company who becomes a fact witness in a particular issue. I wouldn't necessarily be representing that particular employee at the deposition because I'm representing the company. But that employee may be nervous and may have important information to provide, and so I can still talk with that employee, let that employee know what is coming, what types of questions might be asked, and even if I'm not their lawyer, I can still get them, help them prepare for the deposition, at least give them an understanding of what it's going to look like. And that really goes to your second question as well, which was the role of the lawyer. Certainly, a lawyer can have a role in getting a client or an individual ready for a deposition. And as you've said at least a couple of times, I think, the world of the law is really foreign to people that don't live in this world. And there are certainly things that happen, and it can look very scary to walk into a room with a court reporter and lawyers, and just the mere fact of being in that environment can be stress-inducing. So talking with a lawyer ahead of time and finding out what the room will look like, what the questions might be, what form the questions might take, sometimes that can help take some of the stress away from someone who's sitting down for a deposition.
Yeah, do you ever find it's like, you're not speeding, you're not doing anything wrong, but there's a cop behind you. So you get a little nervous for some reason, even though you don't need to. Do you ever sense that as well? Like, you're not doing anything wrong. This is just normal, everyday stuff, me asking you questions, but the person you're dealing with, whether you're a client or for background, is just a little on edge because it's a different kind of, scenario than they're used to, and law is involved, if you will.
Great example of the police being behind you in your car. I mean, I experience that all the time when I call up an individual, tell them that I'd like to have a meeting with them to discuss something. The fact that I am a lawyer calling them causes their palms to sweat. And so anybody who's going to be called in to testify, and I go back to an area that I'm pretty familiar with, which is the healthcare provider area. I cannot imagine me not having any medical background to speak of going into an OR and attempting a surgery, or attempting to take out someone's appendix. I get nervous just thinking about being thrown into that situation. Can you even imagine? Well, that's what a doctor or a healthcare provider has to feel like, at least to a certain extent, when they walk into my world, which is the world of law, where we give you an oath, we swear you to tell the truth, and then we pelt you with questions, and you're always wondering, oh gosh, are they going to twist my words? Are they going to use my words against me? Are they going to ask me confusing questions? So your example is exactly right. It makes for a stress-inducing situation no matter what. In a deposition, though, there's not a whole lot that the lawyer can do at the time of the deposition, because if it's properly noticed, if the parties are all there, if assuming everything has happened according to the rules, the lawyer has the right to ask questions of the deponent, the person sitting there taking the questions. And the lawyer really does not have an actual role. I can object to questions if I feel they are unfair. I can object to questions if I feel that they are confusing, or if they're compound questions, or if they're being asked to harass the individual. I can try to make sure that the deposition remains respectful, that the deposition remains fair, but I can't answer the questions. I, the lawyer, am not under oath. I, the lawyer, am not the witness. And so once the deposition begins, there's not a tremendous amount of control I, as the lawyer, have in how the deposition will take place, except for those objections that I mentioned. When a lawyer objects during a deposition, let's say the questioner asks a question that makes absolutely no sense or seemingly makes no sense, and there's no way that a reasonable person would understand what the person's asking, I can object, and I place my objection by saying something like, I object to the form of the question. I'm not supposed to say anything more. Under the rules, I'm really supposed to simply object, put the objection on the record. If it becomes a problem down the road, we can take that transcript, go to my objection, go to that page and that line number, and ask the court to rule on my objection. But I can't really do much more other than place my objection on the record. There are times when I might object, and the other side, because we have a good relationship, because we get along, and because we are giving each other mutual respect as lawyers, the lawyer may say, well, Rob, what are you objecting to? Tell me what your objection is, and I'll try to fix my question. And under that circumstance, I would feel comfortable giving more of an explanation of my objection.
Can you plead the fifth in a deposition?
You can plead the fifth in a deposition if you feel as though a question that you have been asked or an answer that you are giving might provide criminal liability, or might provide information that could lead to criminal charges of some sort. You can certainly plead the fifth. That doesn't happen a lot in my type of lawsuit, which is a civil proceeding. as opposed to a criminal proceeding. But there are still times, even in civil proceedings, where someone may ask a question which I, as the lawyer, might say, I believe that gets into areas that are inappropriate for this deposition, and I may take a sidebar with you and say, as my client, I think that you need to plead the fifth, which means you are basically saying I have a right not to incriminate myself. And if you plead the fifth, it is essentially the other side is essentially on notice that the question that was asked or the testimony that could be provided could put you at jeopardy to incriminate yourself. In the civil arena, that doesn't happen very often, but it certainly is always something a lawyer should have his or her ears open to.
And so, I keep coming back to the idea of it not being something that should be intimidating, and you go out of your way to make sure that's the case. We're not talking police interrogation here, right? Beside the one-sided glass and all that, or two-way mirror or whatever, That's an interesting question, and my mind is now sort of swimming in examples in the past of times when it did feel a little like a police interrogation. Certainly not a police interrogation, someone on the other side in a uniform or with a badge, badgering you, telling you that you have to tell the truth and screaming in your face. One thing about depositions is lawyers have different styles. Some lawyers are very conversational. Some lawyers live by the adage that you get more flies with honey than you do with vinegar. And they try to make you feel as comfortable as possible in hopes that they will make you feel so comfortable that you talk a lot. Other lawyers have different styles. There's a lawyer that I've worked with a number of times throughout my career, a plaintiff's attorney who had quite a practice in medical professional liability and sued healthcare providers a lot. Usually in that lawyer's depositions, he would come out of the gate with the $64,000 question. So instead of starting with, hi, my name is, and tell me about yourself, where did you go to school, where did you grow up, he would come out of the gate and say, isn't it true you stuck the needle in the wrong artery? And there was no warm up. There was, and so in that sense, you have to be prepared as a deponent, as someone being deposed. You have to be prepared for almost anything. And that's certainly something I go over with my clients when I'm preparing them for deposition, is they need to understand that the lawyer has control over the types of questions and the way that they would question. The deponent, however, has the ability to take breaks when they want. They can consult with their attorney most of the time during a deposition, with one specific exception that I can tell you about. But the lawyer who's asking the questions really can ask them any way he or she wants to. So, and just to, since I gave you that teaser, the only time that a person being asked questions at deposition can't consult with their lawyer is if there's a question on the table. And there's some case law about this issue. And generally speaking, the case law suggests that if there's a question on the table, the best course is for the deponent, the witness, to answer the question first. And then if they need to consult with their lawyer, they do so after. And that's pretty obvious. I mean, if you're asked a difficult question and you want to go talk to your lawyer and then you come back and answer that difficult question, it certainly seems as though you've gotten coached in the hallway as to how to answer it. And in order to avoid that circumstance, most lawyers will advise their witnesses to answer the question first. And then if we need to talk about it and come back and provide additional testimony, we can. But we should not take a break and talk about a question while it's on the table. Okay. And we're talking with Robby Aliff, a member at Jackson Kelly, and we're looking at what is a deposition, what goes on. We've discussed all that, what's going on in the room, what role is the attorney, how is Zoom, COVID, all that affected. depositions, what has changed. So let's ask this one as we get close to wrapping up here. I made an honest mistake. Remember, honesty and the truth aren't the same thing. Someone could honestly, but you and I are recording this on a Thursday. Someone could honestly think it's a Tuesday, right? Like they screwed up, but it wasn't. You know what I mean? Like they honestly thought. So honesty and truth. So if someone makes an honest mistake during a deposition, can they change their testimony?
The answer to that is yes. And here's how that would happen. After a deposition is completed, the court reporter, the stenographer would go back, transcribe the deposition into written words on a page, provide a copy of that transcript to the lawyers and also to the witness, if the witness chooses to read it. And you can read that testimony for accuracy. If you read back through and realize that it was either transcribed incorrectly, which does happen, although very, very infrequently. We've got extremely good court reporters, and so it's highly unlikely that you're going to have a mistake of transcription. But you could read through, and the real answer, the honest, truthful answer is yes, and for whatever reason at the time of the deposition, you said no. You can do what's called an errata sheet, and you've got 30 days, usually about 30 days, to provide an errata sheet following your deposition transcript completion. And you can identify the line number and the page number, the answer that you gave, and the answer that it should have been. And you can attach that to your deposition as a way of identifying that you found a mistake and you wanted to change the testimony that was transcribed. You have to do that with the understanding that the other side or someone else in that lawsuit can ask you questions about why you decided to change the testimony. Right. If it was a transcription error, that's easy. And sometimes we can even get a copy of the audio of the deposition to prove that a transcription error was done. But if you really do change your testimony, if you change your answer from the light was red to the light was green, and you do so after the deposition testimony when you sat there under oath, you can expect some pretty tough questioning at a trial from the witness stand about why you decided to change your opinion about the light color. And so it's really, really important you do the best you can at the time of your deposition. It's important that you know throughout the time of your deposition that you are doing so under oath. And if there is a situation where you have testified incorrectly at the time of deposition, that's another role of the lawyer. There are times when I've had witnesses who simply are nervous and they either provide an incorrect statement or something that may not have been quite as fleshed out as you might like for it to have been. And I, as the lawyer, at the end of the deposition, have the opportunity to ask questions as well. And so there are times when I've said, earlier in the deposition you said this, and I'd like to discuss it a little more because I don't think it was completely clear. And then I can ask questions to hopefully elicit what I believe to be the accurate answer in that situation.
Yeah, and it's amazing how quickly that happened to me just the other day. I'm not making this up. At the eye doctor, I said one thing to the nurse and then realized, I said no, and I should have said yes. When the doctor came in, I had to say no, I actually meant yes to her question. And it's amazing just how quickly you can get stuck in yes, no, and realize, it really is an honest mistake. And I would imagine happens more often than not in your field.
Absolutely. And once again, as we've talked about earlier, this is a stress-inducing situation. It is foreign to the person that's being asked the questions most of the time. And you can have a mistake of memory. You can have a misstatement. And usually people understand that. I mean, obviously, if it goes to the heart of the issue, the red light versus the green light issue, that's more problematic. But if it is, misremembering the year you graduated from high school or misstating the birth date of someone who's an insignificant witness in the case, usually that's not a big deal. Where it becomes a real issue if it goes to the heart of the case, if it goes to the heart of the matter. And then if you try to change your testimony on those types of things after you've sat through a deposition, it does open you up to cross-examination as to why you've changed your answer.
Okay. Well, as we wrap up, is there anything you want to add? I do want to add that we mean this. Please, if you have any questions about this, seek out a responsible professional licensed attorney like Rob, someone at Jackson Kelly. If you reach out, we will get you in touch with the right people who can provide the experience you would need in that situation. Was there anything you want to add to depositions or things we haven't covered that people really need to know?
I guess, Josh, I would say two things sort of in closing. First of all, depositions are important. They're important events in a lawsuit, and it's important to prepare appropriately for them and treat them with the level of importance they deserve. So if you are asked to give sworn testimony, if you're asked to give testimony under oath, it's not a bad idea to talk it over with a lawyer. It's not a bad idea to have a lawyer present. Certainly if you are a defendant or a plaintiff, you would have someone there because you'd have legal representation. But it's never a bad idea to at least talk with a lawyer about how best to prepare. And I guess the last thing is I've given several examples and several ideas during this conversation about the way that I approach depositions. There is no one perfect way to prepare. You may talk to 5 lawyers and they have 5 different ideas about how to prepare or what things need to happen. And that's to be understood because every lawyer has a different style and a different understanding. But I don't know of any lawyers who would say that depositions are not important. I don't know any lawyers who would say that you shouldn't take them seriously. How you handle them, how you prepare, there may be some difference of opinion there. But they are very important and should be taken as important anytime you're asked to give one.
Okay. And again, people can get a hold of you by emailing you. It's RALIFF, Robby Aliff, RALIFF at jacksonkelly.com, or they can call the office there in Charleston at your office, 304-340-1286. That's on the website. They can find you there, or we can get them in touch with someone who can help if Robby's not available. Robby, we appreciate it. And do you want to touch real quick on, just to promote yourself, I think we should, the mediation that you will be beginning to do as well?
Yeah, Josh, thanks. I'm starting to offer my services as a mediator in litigated cases. I've had the good fortune during my 25 years to try a lot of cases in courtrooms around the state of West Virginia. And there are certainly cases where the only way to resolve that dispute is by getting into a courtroom in front of a jury and asking a jury to determine the outcome of a particular dispute. However, the vast majority of matters will be resolved through resolution by settlement or having the cases dismissed. And the number one way to accomplish an early resolution or a resolution outside the courtroom in West Virginia is through the mediation process. A third-party mediator would come in, listen to both sides, talk to the lawyers from both sides or various sides. There could be multiple parties, and help those parties find a resolution somewhere in the middle, if you will. And there's a process that a mediator goes through to get the parties to a place where they are open to the possibility of resolution. I recently had the opportunity to attend a 40-hour program on mediating the litigated case where I've learned some of those strategies. I feel like I'm an expert in the process of mediation at this stage. And even though I have participated in mediations over the 25 years that I've practiced, I've always participated in those mediations representing a party. So now I'm mediating cases as the mediator, as the person trying to bring the parties to some resolution. And I look forward to doing more and more of that as we go forward. I feel like I'm able to listen to the parties, allow them to have their opportunity to explain themselves, and then talk to them about the benefits of having a resolution outside of a courtroom where they still have control over the outcome. So if there's a need for mediation and you're looking for a mediator, give me a shout. See if I might fit the bill.
Great. Thank you so much, Rob. We appreciate everyone listening. Again, jacksonkelly.com, or you can email Rob at RALIFF at jacksonkelly.com if you have any more questions. Rob, thank you.
Thanks, Josh. Have a good day.